Welcome back to the Dershow. Big breaking news just a few minutes ago. Fox settled its suit by Dominion for $750 million. I have to tell you, I've been doing this 60 years. I do not understand that settlement. I guess the best explanation for it comes from Abbie Hoffman. Remember Abbie Hoffman in the Chicago Seven? He once famously said, "In the halls of justice, the only justice takes place in the halls," which means settlements and negotiations and plea bargains. Well, this settlement is very, very difficult to understand. It was agreed to for half what they were sued for. They were sued for 1.6 billion, and they settled for about three quarters of $1 billion. Um, as far as I know, Dominion suffered no damages. I don't think they could have proved $10 worth of damages at a trial. They came out smelling like a rose. The only damages that was suffered extensively by Fox as a result of disclosure of emails by some of its leading employees. But I don't understand how Dominion suffered at all. The judge made a finding, improper in my view, but he made a finding that Dominion did nothing wrong, essentially, and that the fault was all completely on Fox's. That's not the kind of issue that a judge should be allowed to settle under the Seventh Amendment. The Seventh Amendment of the Constitution basically says all issues that were tried at common law by a jury must be allowed to be tried by a common law as well, and no judge can overrule issues that were properly decided by a jury. And it was really up to the jury to decide whether or not the Dominion machines were hackable or were hacked, or whether the election was fair. Look, I believe the election was fair. Donald Trump does not believe the election was fair. Millions of Americans believe the election was fair. Millions of Americans believe the election wasn't fair. Who gives the judge the power to make a decision about a fact like that, especially since he didn't hear any expert testimony about the machines and about the accuracy of the machines? But let's remember this is Delaware. I've argued cases, I think it's now 32 states out of the 50, 32, maybe 34, something like that. I've never argued in a more corrupt state than Delaware. In Delaware, the judges basically pick each other. They come from a small number of elite law firms, and then they go back to those law firms and they favor the lawyers from those law firms. The favorite word in Delaware, everybody knows it. It's no secret, is home cooking or home court advantage. If you're a Delaware lawyer, you get a home court advantage. I argued a case there, and the Chief Justice just cut me off, wouldn't even let me essentially argue my case, but we wouldn't settle. My client was tough, really, really tough, and he lost every battle, but he didn't settle, and he won the war and turned his small company into a very, very large and very successful company. And so, settlement is not something that is in my blood. I'm a fighter, not a settler. But I know how to settle a case, and I've settled cases. And this case was eminently settleable, but not for, not for $750 million. There's something we don't know. There's more information that would have come out. Because right now, I don't see what Fox gains from a settlement. All the bad stuff has come out. Then they have to pay money. They would have won this case on appeal. I would have taken this case. I've never done a contingency fee case in my life. I would have taken this case to the Supreme Court of the United States on a contingency fee. That's how sure I am that the Supreme Court would not have allowed Dominion to collect $750 million or $1.5 billion. That's how certain I am. I could be wrong. The Supreme Court might have denied certiorari. I don't think they would have. I think they would have taken this case because it involved claims about a federal presidential election, and I think that most good appellate lawyers could have won this case. I believe I could have won this case in the Supreme Court had the verdict gone against Fox. I don't know how the verdict would have come down in front of the trial. Remember, this is very much a blue state, Delaware, the home of the president. And a state which is very, very controlled by Democratic politics. I don't know who the jury pool was and whether the uh, d- defendants in the case could have gotten a fair shake in front of the jury, but I can tell you that appellate courts would have taken a dim view of this case because this case has a major chilling effect on freedom of speech. I know from personal experience, unfortunately, I'm not free to disclose the details of it, but I know from personal experience that networks have refused to allow legitimate, centrist, thoughtful people to get on the air for fear that they would be subject to a Dominion type lawsuit. So already this case has had a chilling effect on your First Amendment rights and my First Amendment rights. Remember, the First Amendment doesn't belong only to the speaker or to the networks, it belongs to the listener, the viewer, to you, and to me. We were entitled to hear views we disagree with. Thomas Jefferson, in a letter that I have on my wall, a handwritten letter on the 25th anniversary of the Declaration of Independence, says we have nothing to fear from the false statements of some as long as others are free to correct them. That's the marketplace of ideas. I think it was perfectly okay for Fox to put people on the air, including one of my clients, Mike Lindell, who has a completely different view of the election than I do. But so what? I think I'm right. He thinks he's right. Let the public judge, and the public has judged. And in the marketplace of ideas, the vast majority of Americans believe that Joe Biden won the election fair and square. Were there problems? Yes, of course there were problems. Were there some states that had constitutional issues? Yes, Pennsylvania did. And if the Supreme Court had taken the case, and if there were enough votes that separating out winner from loser that would have been affected by a Supreme Court decision, they would have reversed what Pennsylvania did, allowing voting to continue beyond the statutorily permissible time. Article 2 of the Constitution gives that power only to the legislature, not to the court. So the election wasn't perfect, but it wouldn't have had a different outcome, even if it had been perfect. So, but that's for juries to determine, not judges. Judges should have a very limited role. They're umpires. They're supposed to call balls and strikes. Now, under the new, obviously, Major League Baseball rules, which I leave to you to decide whether it's going to improve the game or hurt the game, umpires have a greater role. They can actually determine the outcome of a game based on whether or not a pitcher waited too long or a batter didn't get into the box quick enough or a pitcher threw to first base one too many times. But in general, judges are supposed to be umpires, and they're not supposed to determine the outcome of a case. Fox did not waive trial by jury. There are very few trial by jury cases, by the way, in Delaware, because most of those cases are in the Chancellery Court, which really isn't a court at all. It's a group of self-appointed and self-continued judges that start out in a limited number of law firms and go back to a limited number of law firms. It's an inside job, and as you might see, I'm not a big fan of the Delaware system of justice, but they don't have as much experience with jury trials as many other states do. And I can see lawyers; they're very conservative. They're very oriented toward minimizing risks. I can see them suggesting the possibility of a settlement if the case could have been settled for the amount of the legal fees that would have been expended, maybe $50 or $60 million. All right, I understand that, but $750 million is a chunk of cash, and an admission of mistakes. Okay, you can admit that certain of your people made statements that they shouldn't have made, but that's, again, if this were Facebook or if this were Twitter or if this were YouTube, they would be exempt from defamation lawsuits because the rule is they can post whatever is posted, and then maybe they can take it down. But even if they don't take it down, even if they know they're wrong and they don't take it down, they can't be sued. Is there that big a difference today between the networks, Fox, CNN, MSNBC, and Facebook? I think Facebook is probably more influential today. Yahoo, all those online medias, and yet they're exempted from exactly this kind of lawsuit. And I think Congress is going to go back to the drawing board and consider whether to give perhaps a little bit more exemption to networks and a little bit less exemption to social media so as to level the playing field a little bit. But I have to tell you, we don't know everything. And that's why I can't criticize the lawyers who recommended the settlement of the case. I don't know if the lawyers recommended the settlement. I suspect they did. But certainly Murdoch had a major input in the decision to settle. I know some of the lawyers in the case, and they're good lawyers. But they had to know, because every lawyer has to know, that there is a very significant chance that any verdict against Fox would have been reversed on appeal, either on appeal to the Court of Appeals or on appeal to the Supreme Court. Every good lawyer had to know that. And yet they settled this case. And usually a settlement reflects the likelihood of success, on appeal. This didn't do that. There's something else going on here. Again, I've been doing this now a lot of years, and I've seen a lot of settlements, and I've rejected a lot of settlements, and I've accepted some settlements. Something is not what it appears to be here. I will tell you categorically that it was a greater likelihood of Fox winning on appeal than losing on appeal. Whether it's 55-45 or 60-40, I don't know. But I do think that, considering all the appellate issues, the way in which the judge took away many of Fox's defenses and made determinations of fact, it's a determination of fact that the election was fair and that Fox lied about it. Those are not things that judges should be decided on summary judgment motions. They can decide on summary judgment motion that Mr. A or Miss A on Fox said this, and then they put on the air something else. Okay, that's a pure statement of fact that maybe a judge can take into consideration on a motion for summary judgment. But ultimate issues, certainly the issue of malice, recklessness, knowledge of the falsity, these are issues that a jury could decide either way. And an appellate court might very well decide. Remember, there are two justices already who have said, others haven't declared, but at least two justices have said that they would like to reconsider the malice requirement when a public figure sues. In this case, of course, we have two public figures. We have Fox as a public figure, and Dominion is a public figure. And the question is, should there be a requirement of malice? And if so, what is the instruction that is a proper instruction on malice? That would have been an issue in this case. And instructions are frequently a basis for reversal of conviction. I would say, of the many, many cases I've had where judgments of lower courts have been reversed, and I've been fortunate to have many of those. I've argued successfully, lots and lots of appeals. A lot of them have been based on instructions. A lot of them have been based on the failure of the judge to allow the defense to put on a full and complete defense. And I think here the judge did fail to allow Fox to put on a full and complete defense. And I don't know what his instruction would have been, but I have to tell you, I doubt it would have been an instruction that could necessarily withstand appeal. So this is the end of the case. It's over, but it's, I think, the beginning of an inquiry as to why this case ended so abruptly and so one-sidedly. This was a fundamental loss for Fox and a windfall victory for a Dominion, which is not this mega company. By the way, it's not. It's owned by a hedge fund. It's owned by a New York equity company, which bought 75% of it. I don't remember the exact figures, but these are not the most sympathetic characters in the world who have gotten this windfall of $750 million, and they suffered no damage. I challenge anybody from Dominion to tell me what damage they suffered. Have they had fewer states hire them to count? I don't know that. Maybe they have, but I don't know that. And if so, is it as a result of Fox? I doubt that very much. So this is an enigma wrapped in a mystery, and I'm here to tell you that something doesn't smell right. I'm here to tell you that what you've seen and heard and what was stated at the press conferences are the tip of a very deep iceberg. I hope we will learn what's beneath the sea and what is hidden from the public view, because remember, Fox is not just a company, it doesn't sell widgets. It sells First Amendment protected news and opinion. And so we, the public, we have a right to know. We probably even had a right to have some input into this decision. This is not a purely business and commercial decision, because networks will be chilled. They will not allow opinions to be expressed on the air, even if they disagree with the opinions, and even if many people share those opinions. And it's a very bad day today for the First Amendment, a very bad day for the Constitution. I'm going to a dinner, which is why I'm dressed up, not because I'm on my podcast, but I'm going to a dinner tonight celebrating this great organization called FIRE, Freedom of Individual Responsibility, which has taken over from the dead American Civil Liberties Union in protecting free speech. They're having a gala dinner tonight, and they're honoring one of the founders, a close friend of mine. And so I'm wearing my constitutional costume, my shirt, and here's my tie, which has the text of the Constitution on it. You can read it. I'm not going to show you my socks, but my socks have pictures of Thomas Jefferson. So I'm in costume to defend and protect freedom of speech and the First Amendment. Jefferson would not like this settlement. Madison would not like this settlement. Hamilton would not like this settlement. Mr. Murdoch may like this settlement. I doubt that he does. But obviously, for him, $750 million is not going to impact his major bottom line. Fox is doing very, very well, and will continue probably to do well because it appeals to a large segment of the viewing and listening audience. But I don't think it made the right decision. Again, I can't second guess its lawyers, just based on what I know today. Had I been their lawyer, had I been their CEO, I think I would have recommended fighting this case. I think I would have recommended taking this case to a jury verdict and then appealing. If you win, the other side would appeal. If you lose, you would appeal. And so that's would have been my recommendation. Again, I probably know as much about appellate law as any lawyer in America. And I am telling you, based on my knowledge, again, I don't know all the facts, I don't know what would have come out, but I'm telling you that I think, had based on the record that I have seen, had this case gone to a jury and had the jury ruled against Fox, I think there's a substantial chance, a better than even chance, that the verdict would have been reversed and sent back, at least for a new trial with a judge that wouldn't have directed a verdict essentially on some of the issues, the factual issues, and on other issues as well. I don't know whether the fact that the judge was threatening to find ethical violations against the lawyers in this case might have impacted the outcome. The judge then went out of his way to praise the lawyers after having condemned them, because the judge probably thinks he's brought about a victory in this case. Judges love settlements. So bad day for Fox, bad day for the First Amendment, bad day for Americans who want to hear diverse points of view, bad day for real diversity of opinion, good day for Dominion owners who have enriched themselves in a windfall and have gotten profits that they didn't deserve, that they would never have earned had they had to prove to the jury actual damages. So, interested in your letters, see what you have to say about this, interested in how the press reacts to this. I would think that the newspapers and the media would be concerned about this case because it's already had a chilling effect. I can tell you that I have personal knowledge that this has already chilled speech and as a ready cause cancellations and preventing of views being heard that are fully protected by the First Amendment. So the Constitution today is shedding some tears, and the fact that Dominion is jumping up and down with joy should not bring joy to Americans who care deeply about our constitutional rights and about the right to hear a diversity of points of view. So let's turn to some of the letters. Um, Quite a few. Ted Cruz has made a proposal to the Texas bar that any applicant who graduated from Stanford Law School in 2023 to 2025 answer in writing if they participated in the shoutdown of Judge Duncan. Do you think this is a good idea? It's a very interesting question. I think that any student at Stanford Law School or at Yale Law School or at any law school who participated actively in preventing a speaker from expressing his or her points of view should be disciplined and should be at least subject to hard questioning before being admitted to the bar. And I suspect that would have been the case had it been a right wing protesters who had prevented a left wing speaker from speaking. I do not believe that we have neutral application of these rules, even in a state like Texas. But I also don't want to see any form of McCarthyism introduced, and I worry about painting with too broad a brush. So I'm going to leave it to you to decide whether it's a good idea or a bad idea. I think it's a good idea to have the names of the students who publicly have identified themselves as supporters of repression of free speech. Those names should be published so that law firms and judges and others should have the ability to question them about their commitment to the Constitution and to free speech. But I think it's a close question, and I can imagine how reasonable people could disagree with that. Okay. Thanks for succinctly stating the issue in the Fox case. This was obviously yesterday before the settlement occurred. It took me 5 minutes to explain the issue to a friend before I saw the show. It seems like a lie believed by millions of people is newsworthy, whether Fox or other news media believe it or not. I think that's correct. I think that, look, it's better journalism to say, look, this is what millions of people believe. We don't believe it's true. CNN does exactly the same thing, mirror image, the exact opposite. They don't say that millions of Americans believe the election was fair and millions of Americans believe it wasn't fair. They just state categorically, as does the New York Times, that the election was fair. That's fine for the opinion pages. That's not so fine for the news pages. The news pages should report the fact that millions of Americans agree with one side, millions of Americans agree with the other side, and the news section should not take sides on who is right. The opinion section should and can and does take sides for who is right. Okay. This is a nice one for me. Professor Dershowitz, you're a national treasure. I've been an electrical engineer for over 45 years. In my 65 years of this planet, I've effectively avoided politics and the media because of irrational emotional biases and misinformation. But now that the adults have truly left the room and the social media has given powerful voices to, I despise anyone who disagrees with me, narcissistic little children, objective, rational voices like yours are truly a rare gift. I pray that you can get back to the days, we can get back to the days when people with opposing political views could actually be friends and focus on facts, not feelings. I wish you well. I completely agree. And this dinner that I'm going to tonight for FIRE, it's the people who are going to be at this dinner are liberals and conservatives, left, right, center, Democrats, Republicans, but they all agree that on university campuses, diversity must include diversity of viewpoints, diversity of opinions. Today, we have millions and millions of dollars, deans and administrators who are in charge of diversity, equity, and inclusion. One of them at Yale, just the other day, the program on diversity, inclusion, and equity invited a virulently anti-Semitic woman to speak who said that the Jews were responsible for the Holocaust, that they basically put Hitler in power and were responsible for their own fate, and that Israel is a Nazi country, all that kind of thing. And this was in the name of diversity, right? Diversity. But the other point of view is not permitted, and the diversity stormtroopers permit one point of view, but not other points of view. The last thing the diversity Nazis want is real diversity. They certainly don't want diversity of viewpoints. They don't want diversity of race or religion. They just want more of who they are, more of who they would like to be. That's their definition of diversity. One of the worst things that's ever happened to universities is the creation of this entire network of diversity, inclusion, and equity. What's wrong with equality? Why do we have to substitute the word equity for equality when equity means exactly the opposite of equality? Equity means inequality, means giving preferences to certain identity groups over others. What's going on today on college campuses is abysmal. Read about it in today's Wall Street Journal. There's an article about why Goldman and Sachs, which was the most successful financial firm, is now failing. I don't mean financially failing, but doing much, much worse. The thesis of the article was that the reason Goldman was so successful is it broke the monopoly that Brahmins, white Anglo-Saxon Brahmins, used to dominate the financial industry, and nobody who was Jewish or black or a woman or Catholic could become somebody involved in finance. And then Goldman Sachs said, no, we're going to create a meritocracy. We'll hire anybody who's good. And they became the giant in the industry. Now they're falling into the trap. They're requiring all their people to come up with unpronounceable pronouns that they have to use in the name of diversity, equity, and inclusion. And the end of meritocracy means the end of the American dream. And we're seeing it so quickly come to an end. And as the article points out as well, instead of merit today, the criteria for hiring seems to be virtue. I didn't even know what virtue means. The hiring people are virtuous because they're picking people based on identity politics rather than on quality. And I have to tell you, when I go and have my surgery, when I fly in an airplane, I sure as heck want meritocracy to dominate the selection of doctors and the selection of pilots. Lawyers, all right, you can do without good lawyers. The world wouldn't end if all the lawyers were mediocre, uh, but nobody wants a mediocre surgeon, and we're moving in that direction. I think if we end meritocracy, and we're moving quickly toward ending meritocracy, and there are some academics who actually have written about why it's important to end meritocracy. Well, I'm not one of them. I don't agree with that. Frankly, Dersh, I don't know how you managed to reconcile your unwavering allegiance to the Democratic Party with the flagrant anti-Semitic nurture tolerated throughout the same party. But the Republicans have a problem too. It was an article yesterday about one of the Republicans who was espousing anti-Semitic themes, and the Republicans haven't done enough to rid their party of the bigotry of the hard right, nor have the Democrats. And so there's some blame on either side. I think the Republicans have generally done a better job, but they're not there yet. See you tomorrow.